Okay, we are now recording. My name's Joseph Evans. I'm with my colleagues Adam Sampson and Sharon Bernardi. We are here for a public deliberation in in-rate petition for special hearing and variance for 6603 and 6605 Pimlico Road. The petitioner is Derech Chaim Inc., which is an Orthodox congregation. This hearing is being conducted virtually because of the situation with COVID. We had several days of hearings, and those were also held virtually. The petitioner was represented by Adam Rosenblatt and Christopher Mudd of Venable LLC, and the protestants were represented by Michael R. McCann. The request here is to permit the tearing down of two homes on the subject properties and the construction of a shul, essentially in the middle of the two properties. And the relief requested is to either relax or excuse compliance with the residential transition area requirements and to permit reduced parking that would otherwise be required for a religious institution. So those, I believe, well, let me give the case number, is case number 2020-0132-SPHA. And I just want to remind everyone that this is being recorded, and this recording will be posted on the Board of Appeals website. So any interested person will be able to hear our deliberations. So with that said, let me see if I can just outline for us in very simple terms the issues that we have to decide. The first, as to the RTA, that is the residential transition area requirements. I guess question number one is, does it even apply to this situation? The petitioner has suggested in their memorandum that it does not apply. And then the second issue is, if it applies, should it be relaxed or I think essentially excused in this situation? And then a final issue is the application or not of the LUPA federal statute, which provides for, requires, in a nutshell, requires zoning authorities such as us to take into account, where appropriate, the fact that that there are religious issues at issue, that there is the question of the impingement on the free exercise of religion or not. So are those the issues? Did I miss anything that anyone can think of? Was that too abbreviated?
Well, is the parking a separate issue from what you just identified?
I think it is, yes. The parking is probably a separate issue, yes.
So you're still getting to that.
Well, I forgot that, but
okay, then I would add that.
Right. All right. So I take it then that we can begin. I wanted to say at the outset, and I think I said this at the conclusion of our actual hearings, that this kind of a case is particularly difficult because everyone on both sides of the issue are people of goodwill, and at the end of the day, there will be some people that will feel good about our decision, and there's some people that will feel not so good about our decision. And I regret that we can't make everyone happy, particularly when everyone is acting, I would suggest in good faith here. And these sometimes thorny issues have to just be resolved, and everyone can't always be satisfied with the outcome. So I do want that to be known to everyone. And I know that we have some 50 people who are listening, 51 now, 52, as we discuss these matters, and more I'm sure will listen when this deliberation is posted online. So, having said that, is there anyone who wants to begin? I can begin if you want, but I'm happy to defer to anyone else who wants to kick this off.
I will defer to either of you, but I would like to just say, in addition to adopting your comments, for the folks that are viewing, at times I'm going to be turning my head and I'm going to be typing. I'm not doing other work. I'm taking notes of our deliberation. So I didn't want there to be any misunderstanding. I take this very seriously, and in fact, that's why I'll be taking notes for our drafting purposes.
Good.
But
Good. Okay.
I'll certainly defer to either of my colleagues.
Well, I don't usually like to go first, but because I chaired the panel, and actually because I think I have some experience with the Arlupa cases that probably the two of you don't, it probably makes sense for me to go first. I would, jumping to the bottom line, my own position is that I would grant the relief requested by the petitioners. I take that position for a number of reasons. First of all, religious institutions are permitted by right in this zone. So the only question is the RTA, and the question of whether it, an aspect of that is whether it, the extent to which it impacts on the health, safety, or welfare of the area. I have seen a number of these cases, of religious cases, I should say, and from a number of different denominations, including Orthodox denominations or Orthodox groups. And I must say that of all of the cases I have seen, and I'm not trying to, this isn't something that goes on a continuum or anything, but of all the cases I have seen, the congregation in this case has been vastly more accommodating and vastly more conciliatory, and vastly more made vastly more efforts to be as unobtrusive as possible. I know that's small comfort to the Blumenthals, but the fact that the rabbi on his own undertook to suggest that the social hall only be available for use during the Sabbath strikes me as a concession of huge proportions, actually. I think Mr. Loeb was seemed a little, I don't think he necessarily agreed with the rabbi's position on that, but, and maybe maybe I would come out the same way even without that condition. But I do want to say that is an exhibition. It's a showing of good faith that is, I think, just overwhelming. And I have seen nothing like this in any of the other cases in which I've been involved. Um, so the so I am quite predisposed to granting the relief for those reasons. I think that the residential transition area requirements do in fact apply here. The petitioners suggested that that it didn't because this is a historic plat. There is a provision at 1B02.3 in the BCCR that excuses certain certain properties from compliance with the RTA, but I think that that applies to the modification of an existing structure, and what we have here is the demolition of two structures, the creation of a new structure, and it would seem to me that the that provision does not apply, and that they did the petitioners did cite to one decision by Judge Mayhew in which he found that this provision did apply, but that was to an existing home whose footprint and whose exterior was not being altered in the slightest. It was just the use on the inside that was being changed. And to that extent, he found that that provision applied, but I just don't think it has any application here. So my view is that the RTA does apply, and I would either relax it or excuse it to the extent it needs to be excused in its entirety in certain features, because it would. It seems to me that to the extent possible, the congregation has made efforts to comply with it, and I want to say that they, reduced the height, and they've done all these other things that show a good faith effort to make this building and to make the activities within the building and around the building to make them as harmonious as possible with the neighborhood. I know that the Blumenthals have suggested, and I'm not unmindful of this, that there are enforcement issues here. In other words, how do we know, for example, that the congregation would abide by the social hall restrictions? Well, we have to, I'm certainly convinced at this point that the congregation is acting in good faith. I see no reason why it would engage in some kind of subterfuge on this point. And, if there are a lot of cars showing up and there are events going on in the social hall, then it will be reported to the zoning authorities and citations will be issued, and we'll have to deal with it as it arrives. But at least at this point, I certainly am of the view that the congregation is acting in good faith, and that restriction for me carries the day. As I say, I might have come to this conclusion even without that, but certainly that is a very dramatic concession. I just wanted to make two other comments. The first has to do with the suggestion from Mr. Kelman that the area to be the context of the application of the RTA is wider than the immediate neighborhood. In fact, I think he had it for the entire area in which the Orthodox community can operate. I forget the name of the word that is. I'm Jewish. I forget the name of the word. So, yes, I thought that was actually quite illogical, and I would be tempted to say preposterous. The RTA, the basis for the RTA is to make a building blend in with its immediate surroundings, and to suggest that something 3/4 of a mile away is a focal point for blending in, I think is really, I don't really even understand how anyone can say that, frankly. I think Mr. Jakubiak actually got it perfectly right on that. But that doesn't matter to me because of my ultimate view of the situation. As to Arlupa, I would grant the relief in this, notwithstanding Arlupa. That doesn't actually change my view of the situation. I think it is fair to note, however, that the county has been subjected to a number of pieces of federal litigation involving Arlupa. The county has fared poorly in that litigation. And some people feel as though the county is being bullied by that litigation. But in any event, in this instance, my own view is that it's not really, to my way of thinking, an operative feature, because I would grant the relief just based on my traditional views of RTAs and the like, particularly where here, this institution, a religious operation, a religious building is available by right, all of the things being equal. So that's sort of where I come out on this. So I don't mean to monopolize the microphone, so I will now relinquish it to either of you, whoever would like to chime in.
Well, I'll go next. I concur with your conclusion. I also reached that before a full understanding from the briefing and reading the cases on our LUPA, which is to say, as you just summarized, I was prepared to grant the relief before even understanding the full application of it. And to me, I think that's important to note.
And if and when you understand the full application of it, please
I'll tell you.
Call me and explain it to me.
Okay. Fair point. I accept that that restriction on my comment. I'm not quite as now. This is just going to be, I guess, more so how the drafting of the opinion ends up going. But I wrestled a little bit more with these competing views of the surrounding area, but to a degree, that's more academic law at this point, because it is as a matter of right. I'm sympathetic to the Blumenthal's concerns. I'm actually quite surprised at the overwhelming support, through, at least as the evidence in the case demonstrated, in the community. I do think the location on Pimlico Road and in that area, and with the existing other structures in the area, that this meets the requirements. I'm not as convinced that it has quite the residential appearance that the petitioner's expert says it does. Again, that's not critical. I think he somewhat overstated that, but the totality of the accommodations, I think are met. I think on the parking, which you didn't get into specifically,
You're right.
but I think that the restrictive, the voluntary restrictive uses on the property, together with the Sabbath and requirements for walking on particular holidays, I think achieves the concerns for the parking. So that's not a problem for me either. So I don't have much else to add. There was one issue that came up that I sort of, I think, raised, and Mr. McCann, I think I raised it before he did, but it's addressed in the briefs. And that was the issue of the timeliness of the revised site plan. And I think, I'll just say, since you as the chair handled that issue, I concur that you handled it correctly. And I think I bring to this, or I brought to this a little different perspective from civil litigation that doesn't quite apply here. And I'm still adjusting to that. I sometimes jump in before the lawyer does, because the lawyer that's been doing this realizes that's the way it goes, and I'm not used to it. So I think that the site plan properly came into evidence, and I wanted to address that. I think that probably should be mentioned in our opinion, if the two of you concur. And so I have nothing else to add.
I wanted to add one other point that I forgot to mention. It was relevant to me that the adjoining neighbors all signed the agreement to relinquish the restriction on the activity that would otherwise prohibit this here. I mean, depends how you count. It was either 9 out of 11 or 7 out of 9, but the fact that 5 out of 7, I forget now, but the fact that the majority of the actual neighbors right in that immediate vicinity were willing to accept the shul, I think that also was relevant to me. I know that there were concerns about whether there was untoward pressure, or whether there was peer pressure, or whether there was some sort of background pressure. But that isn't really something we can resolve. I think all we are faced with is the sort of the bottom line, which is the majority of the abutting neighbors were willing to have this, and that was relevant in my calculus as well.
And Mr. Chair and Mr. Sampson, we can align on the conclusion and how we arrived at that conclusion. I agree that the decision could be based on the RTA and not have to reach the ALUPA decision, but I know we will have to address that in the decision. I do want to at least go on record, as you have, that I know this is very difficult for both sides involved, and especially the Protestants, in that they raised concerns regarding just the general welfare and their ability to enjoy their property as they have in the past. And so I want to go on record that that definitely had to deliberate the issues that they raised regarding the enforcement, as you said, but also the traffic and safety concerns. They also, in their briefs and during the testimony, felt that lighting issues were unresolved as well, and all of those, as well as the parking, definitely need to be taken into consideration. But it does appear as if the congregation has been respectful of concerns that have been raised. in the community, and I believe from the testimony that they would continue to listen and hear concerns, and I believe that the lighting plans are still being finalized, so I think that they would address that as well. And because it is also their community, they would have the same concerns regarding traffic and any other safety. So I believe that the community would work together to make certain that it remains safe for everyone who resides there. Regarding the architectural design discussion, I agree with you in that the intent, I believe, is to look at the immediate neighborhood, and so the structure should hopefully be aligned with that, and to look at other communities that are not adjacent to this one. I agree with you that that was not, for me, an argument that I could support. And I know we're going to discuss the parking as a separate issue.
Well, I think that my sense is that the consensus is that we would rule on the parking in accord with what the petitioners have requested. Is that what I'm hearing here?
Yes, from me.
Yeah, okay. That's what I would do as well. So.
Okay.
And
I'm fine with that. I know the Blumenthal's were concerned about how close it is to their property, but as you mentioned, I believe that the petitioners have done what they could to the extent possible to address the concerns of RTA.
Right, I agree with that as well. Does anyone have any further comments? Any other concerns? So just to summarize, I guess we are granting the relief that's requested. The petitioner has included certain voluntary restrictions in their submission, and I assume that we will we will impose those conditions that were suggested by the petitioners. We will I think we need to make sure that the lighting is accounted for properly, and that the parking is appropriate. But those are, but having said that, and I guess we are, it's not clear to me whether the opinion that comes from this needs to address our LUPA or not, but I think our consensus is that we would grant this relief even if our LUPA was not hovering in the background the way it is. Is that a fair summary?
Yes.
Yes, sir.
So there are many people listening in, and there will be, as I said before, many people probably accessing this on the Board of Appeals website. Again, we want to thank everyone for their participation. We want to make sure everyone understands that we have tried to resolve this as best we could, given what the law is, basically. And there will be a written decision that is issued in due course, and that will be also available to all interested people. So with that said, I think we will adjourn and carry on with other business. Is that okay?
Thank you for sharing, Mr. Evans.
Thank everyone for everything.
Thank you.
Thank you.
Have a good day.
You too. Bye.